being on the last benches. But my voice may not reach. If you want to hear me, you can come in front. For those who anyways don't want to hear me, I will sit back. So I would like to begin by thanking NLS. I would like to begin by thanking SIPLA, Students for Promotion of Awareness of Law, and most importantly, Shobhama, who's been my research assistant, who's worked very diligently, very hard, even when her hand was not in proper order, and even Bhavesh, who also assisted me with some of my research. So what I intend to talk today about is, as you know, the topic is India at the ILC in Science into International Law. The first point that I wish to clarify is when I'm a member of the International Law Commission, I'm only an Indian member of the International Law Commission. I'm not an Indian representative of the International Law Commission. There's a vast difference between these two concepts. The Indian representative would be at the permanent mission of India in New York, who would be representing India as such. But I don't represent India because I'm a part of an independent expert legal body. What it means and how it functions will come across to you as I go along in my brief talk and presentation. One of the criticisms of international law is indeterminate. By indeterminate, people mean it is very difficult to find answers to questions. That is, it is very difficult to find straightforward answers to questions. For example, what is customary international law? The answer will depend on who you ask the question. If you ask a positivist international lawyer, he will tell you it is opinio juris necessitatis. That is, you have to have opinio juris plus state practice. That's a psychological element plus the actual element of practice that would represent the existence of customary international law. If you ask a third world international law scholar, a Whaler, he would simply tell you, oh, it's a construct of the Westerners which has been used to colonize the independent world. So it's immaterial. If you ask a critical international law scholar, he or she might say, well, we have always told you international law is intransparent, it doesn't have a clear structure. So customary law is not very clear. Often the answer to the questions depend on the person to whom you're asking the question. So indeterminacy, that is the inability to precisely identify where the law is and what the contents of the law are, is one of the fundamental problems of international law. And why this problem arises is because of the very architecture of international law. When I say the architecture of international law, I mean the way in which, of various factors, as we often use the legal word inter alia, along with other things, but not for this, just for this, but this is one of the important reasons, is the way in which international law is made. We all know there is no centralized parliament. The General Assembly is not per se the parliament which can pass laws. Its resolutions, unanimous resolutions, may become a law at a certain stage if it has sufficient support of state practice. But a resolution of the General Assembly, unlike the law passed by a parliament, is not a law per se. So the process of lawmaking in international law is fundamentally diverse, and one could even say fractured. By fractured, I mean there are different ways in which law is made. And the principal way in which normally a law is made in domestic law, that is not the principal way in which law is made in international law. I give you the example of parliament. And the interesting part is that international law is made by the addressees of the law itself. So in the parliament, we have our representatives, but we ourselves don't make the law. But in international law, it is the states who are the participants, who are the addressees of the law, and they are themselves making the law. So this fundamentally distinct nature of international lawmaking process, and I think international lawmaking process is something on which I have to focus because I will be speaking about the ILC. I am not intending to touch upon other aspects of indeterminacy of the law. Now, indeterminacy exists in all forms of laws, like international law. And one of the ways to counter it is to identify and to very clearly set out what the law is and what the contents of the law are. Let me give you an example about what the law is and what the contents of the law are. The 1958 Geneva Convention on the Territorial Seas said every state can claim a territorial sea. Because it is a customary international norm, every state can claim a territorial sea. But to what extent that territorial sea has to be claimed was never clarified. So we have a rule of customary law saying the territorial sea is customary law, but what is the content of the law was unclear. So you have situations where firstly you are unclear about the law, or you have a law but you are not clear about the content of the law. Let me give you another example, principle of non-refoulement. That is, whenever there is a possibility that somebody may be subjected to one of the international crimes in the jurisdiction, then that person should not be sent to that jurisdiction. That's the principle of non-refoulement. Now, the question would be whether non-refoulement is customary international law. If it is customary international law, is it international law across all fields, or is it customary international law only in the context of refugee law, or it is customary international law only in the context of human rights law, and whether its contents as a rule in human rights is going to be different from its rule in refugee law. So all these questions arise due to lack of precision, the lack of exact articulation of what the law is. You won't have this problem on, let's say, Transfer of Property Act. What is a mortgage? If I ask you what is a mortgage, you pick up the Transfer of Property Act, pull out the section, read it out to me. I'm forgetting it, it's one of the 100 range. I've read it long back now, I haven't gone back to it for several years. So you know where it is, you pull it out, you read it out to me, and you will say, this is what the law is. Now there is one area in international law, I know international lawyers love to keep fighting, but irrespective of that, there is one area of law at least where we can say there is clarity, that is sources. If I ask anybody, what are the sources of international law, you'll quickly pull out the statute book, you'll pull out the ICJ statute, point out to Article 38(1) of the ICJ statute and say, these are the sources of international law. Now that clarity is possible because we have done, in the context of sources, what is called codification of international law. Another excellent example of codification of international law is Article 31 and 32 of the Vienna Convention on the Law of Treaties. Both these rules, both these articles are understood as customary international law. Imagine what the situation must have been prior to 1968, that is before the Vienna Convention on the Law of the Treaties was entered into. Anybody could choose any rule for interpretation. Somebody could use text, somebody could use context, somebody could use object purpose, somebody could use travaux, the legislative intent, somebody could use subsequent agreement and subsequent practice. But after 31 and 32, it is clear it is text, context, object and purpose and travaux and subsequent agreement and subsequent practice, everything thrown into the crucible, but of course having some sort of a chronological applicability. This success is possible, this clarity is possible because there is a process of codification involved. And that is the crux of the work of the International Law Commission. International Law Commission is nothing or an institution which is an output of the process of codification. And the process of codification has existed even prior to the creation of the International Law Commission. It was therefore the importance of the codification which was so understood, which resulted into ultimately the ultimate creation of the International Law Commission through a resolution of the General Assembly in 1947, and the Commission came into being, had its first session in 1948. So technically last year the Commission celebrated its 70 years. And there have been several codificatory conferences prior to the International Law Commission. There was a very famous, rather one of the first codificatory exercise was the Vienna Conference of 1814 to 1818. That's where for the first time states tried to codify something in a more concrete and at a multilateral level. Of course, this codification happens at the bilateral level, but we won't really call it codification, we will simply call them treaties. Because in codification, we are trying to look for principles or rules which are of a multilateral nature, which are universal in nature and could be applied to all states. And that can be achieved once you either have a multilateral conference or some body which is authorized by all states to indulge into the exercise of codification, which in other words is the process of identification, of laying down the precise contents and contours of public international law. So of course you had I told you about the Vienna conferences, 1814, 1819, then there was 1818, then you had the Paris conference, then you have the most important conference which probably everybody has heard of or come across, are the Hague Codification Conferences of 1899 and 1907, which resulted into the permanent Court of Arbitration and Code of Conduct and how disputes have to be resolved peacefully between states. Now what happened was, in all these codificatory conferences, what we see that states were involved in the codification process. Often what they would do is they would try to have a committee of experts. And the benefit of having a committee of experts is that they're not bound by the national lines, they're not bound by the national instructions, they are independent experts. They get together, apply an independent eye to the area of law that they are working on or intending to work on, and thereby accordingly create in a sense a neutral set of rules. Obviously the people who are involved come from different backgrounds. Since they come from different backgrounds, they have different priorities, they have different preferences. Those different preferences in a sense get neutraled out in a process of conversation, negotiation, and then what comes out is pretty much a neutral product, the product that represents principal legal systems of the world. And once you have that kind of a product, it can claim to be universal in nature. That's what international law is expected to be, or aspired to be universal. That is, everybody would like to feel bound by the contents of such kind of a law. As an outcome of this whole codificatory process, the pivotal moment was what is called the Article 13.1a of the UN Charter. Article 13.1a of the UN Charter says it is the responsibility of the General Assembly to progressively develop and codify international law. Now, one of the first things which was very promptly done by the General Assembly was that, of course, the General Assembly has the 6th committee. There are several committees. 6th committee is the last committee, which is the legal committee. And the 6th committee is responsible for the codification and progressive development of international law, along with several other things that the 6th committee does. But again, in the 6th committee, the representatives are from individual states, so they do have their own national priorities. But understanding this problem, the General Assembly very promptly, one of the first things it did was to pass a resolution and to create the International Law Commission. The International Law Commission was meant to be a body comprises of independent experts, and accordingly what was drafted is called the ILC statute, or the Statute of the International Law Commission. The statute of the ILC is not a treaty. It is a document which is appended to a resolution of the General Assembly, which means it is easy to amend, and it has been amended several times. But the amendments have been mostly in relation to the number of members and more cosmetic in a sense, rather than touching any core principles of the ILC statute. I don't think I should really get into the whole election process, the candidature process. That's something you can read and understand. It's very much obvious from the text of the ILC. But what is slightly important and slightly unclear, which I need to clarify, and after which I'll move on to give some insights into international law, and then speak a bit about how India has been involved with the ILC. So, apart from the technical election and all those things, the core provisions, or rather I would say the pivotal provision of the Statute of the International Law Commission is Article 15. Article 15 sets out that the Commission is responsible for progressive development and codification, and what is the nature or meaning of progressive development and codification has been clarified in Article 15 and the articles which follow thereafter. Now what it says is, codification normally takes place in an area where the law is sufficiently developed. One of the examples was law of the sea. Law of the sea is one of the oldest areas of international law. One of the prominent writers of international law, is known as the father of international law by the Westerners, not by us, is Hugo Grotius. Hugo de Groot. And Hugo Grotius, his famous treatise is Mare Liberum, the freedom of the seas. Now, freedom of the seas, Mare Liberum, is one of the oldest branches of international law, where there's enough state practice. There's so many things happening all the time. And all of this was an area which could easily be codified, and it was accordingly codified, and which resulted into the first law of the sea 1956 text, draft articles, which resulted into 4 Geneva Conventions of 1958. The other area, which was obviously ripe for codification, was treaties. The Commission completed it in 1968 and then resulted into the Vienna Convention of 1969, which is codificatory of rules and principles in relation to treaties. Now, these are the areas where there was enough state practice. And as we say, the big beasts have been killed by the Commission by now. Because there are issues of diplomatic and consular relations, properties, all these prominent issues where there is a very large mass of state practice which are easy to codify have been completed. Because the nature of the codificatory process is such where you already have great amount of raw material. Now, what is that raw material? That raw material has been identified in Article 15 of the statute itself. First, that is to be state practice. State practice, as I suppose you all know, is the behavior, is the way in which the states have acted over time. You can find this state practice either in the statute book, the laws that have been passed. You could find that state practice in statements which have been made by appropriate representatives of states. There are various ways of identification of the state practice. And recently, the Commission finished second reading on the topic of identification of customary international law, where the Commission has specifically identified which are the ways in which we can identify state practice. So, state practice is something which forms the basis of codification. The second thing that forms the basis of codification is the word precedent. Now, precedent is a fairly controversial word, not for us, but outside our country. Because we are a common law jurisdiction. In a common law jurisdiction, the judge makes the law. Therefore, the lower courts are bound by precedent, that is the law that is made by the higher court. But in civil law jurisdiction, they don't follow the rule of precedent because the judges cannot make law. So precedent is slightly an awkward word for civil lawyers in a sense. But what the word represents is that in a codificatory process, precedent fundamentally means and involves using judicial decisions. But whose judicial decisions? It is not clarified, but it's pretty obvious it has to be by some international court of tribunal. So in a codificatory process, the decisions of international courts and tribunals do play a very important role. For example, if you look at the rule of self-defense, the rule of self-defense, although codified in Article 51 of the UN Charter, fundamentally comes from the Caroline incident as to in which situations you can invoke the right of self-defense. This incident is not really a judicial precedent in a sense, but is an example of state practice. But judicial precedent may be, for example, the way in which the ICJ declared the resolution of the General Assembly on friendly relations between states and customary international law. That is a precedent, example of precedent. So such precedents can form the basis of a codificatory process. And the third source is doctrine. Doctrine is fundamentally, as it actually comes from French, la doctrine, which fundamentally means writings of publicists. So whatever has been written by scholars of international law, it is certainly a subsidiary source of international law under Article 38(1)(c). But here in this context, D probably, here in this context, what it happens is we do take into account the writings of publicists as one of the ways for codification. Because the writing by itself is not the law, but in the writing they are identifying the law, and that identification can go into the codificatory process. So codification is a big chunk, but as I told you, it is not always possible to codify, because codify needs a lot of material which forms the basis of that writing. Then what matters is progressive development, and it's often controversial as to what it means. If you look at the text of Article 15, it gives the impression that progressive development is trying to develop an area of the law which is not yet sufficiently developed, which gives the impression that there could be certain areas where you have the features of codification, but the features of codification are so little that by itself cannot amount to codification. And then what you have to do is you have to progressively develop, that is, you have to develop the law by using some sort of innovation, trying to bring in new ideas, and trying to build on whatever exists, although in lesser quantity. There are other ways of looking at progressive development, because the statute allows preparation of new conventions. So it's possible that the Commission gets together and drafts a new convention altogether. This new convention need not be based on practice. The Commission drafted what formed eventually the Road Statute was drafted by the ILC. The Commission adopted a very distinct and a unique process. We didn't have a special rapporteur, had a committee to save our time, and we got a draft prepared and turned around in a fairly swift and quick manner. A lot of the things there were in a sense progressive development, because we didn't have precedent or we didn't have examples of codification. So the kinds or the recent work of the Commission on crimes against humanity, while the crimes against humanity may be customary international law, the mechanisms for redressal, the mechanisms for cooperation between states are not essentially in the domain of codificatory exercise, but more in the domain of progressive development. Now with these two pillars, which form the methodological conceptual foundation of the work of the ILC, now let us look at how the ILC functions. And that functioning of the International Law Commission is really the practical way in which the Commission works, or what is called the working methods of the Commission. There are several bodies and several committees in the Commission. We need to understand three important institutions involved within the Commission. The first is the plenary, the second is the drafting committee, and the third is the special rapporteur. We should first understand the role, the relationship, and how they all three of them function in relation to each other, or they generally function in the domain. Plenary sessions are normally open for public, so anybody can come, sit, listen. Plenary sessions are the sessions where members debate, and the debate are open to public. But the debate happens based on certain topics. Those topics are to be identified by the Commission. That identification is done by what is called the long-term program of work. The statute of the Commission itself provides that the International Law Commission should survey the entire field of international law, find out areas of international law which are ripe for codification and progressive development, and then start the process of codification and progressive development. The first study on this topic was done by Sir Hurst Lauterpacht, and Lauterpacht identified a set of principles, a set of areas which could be codified in the future. And then at a later stage, the Commission appointed what is called the Long-Term Program of Work Committee. In the Long-Term Program of Work Committee, different members come up with proposals, submit their outlines, which are discussed thoroughly by the members. After discussing them thoroughly, those proposals are sent off to the General Assembly and annexed with the report of the International Law Commission. Based on the reactions of the state, it is eventually decided to move the topic from the long-term program of work to the current program of work. Current is the ongoing program of work. Now in the ongoing program of work, what normally happens is a special rapporteur is appointed by the Commission. The special rapporteur goes back, takes his or her time to study the area, and after studying the area comes back with a report. The report is submitted to the Commission in advance, and then the Commission gets together and in its plenary sessions, that is a session which is open to all, where all members participate, all members get together and have a threadbare discussion of the report. A report is normally a discussion about all the ways in which we identify the existence of the law, and which would basically mean something based on the doctrine, something based on precedent, something based on state practice. And based on this material, the special rapporteur would have prepared a report, given a background, and after giving a background would propose a draft article or a draft provision. Now this draft article or this draft provision is fundamentally the codificatory exercise. I told you about the indeterminacy of the law. So this is trying to reduce the indeterminacy of the law by trying to pin down as to what is it precisely that the content of the law is in that field. The report gives the background, and the precise content gives the precise provision, or the draft provision gives the precise content of that particular provision in the area of the law. The report is, as I told you, circulated in advance. All the members express their opinions on the report. You can hear all of this. It is available in public domain. If you go on the ILC website, you can listen to the audio recordings of the debates of all members of the International Law Commission. Like the boring lecture that I have been giving so long, the plenary sessions tend to be monotonous because there are speeches given by members. As you must have noticed by now, like the long speech I've been giving here. We all give long speeches in the commission. But then we have some exciting things as well. What is called a mini debate. Mini debate is whenever a member is uncomfortable or disagrees with a certain position or wants a clarification on a position taken by a certain member, can start a mini debate. So after a member has said something, other members can simply raise his hand and say, I want to have a mini debate, and start the discussion and get the ball rolling. Yes, some of them do walk away. But that's not a mini debate. So the plenary is where we discuss the report threadbare, and after discussing all the contents of the report, finally the plenary decides that this provision has to be sent off to the drafting committee. There is, the chairman asked if the plenary agrees. Normally we work by consensus. There was one unfortunate incident 2 years back when the commission voted on what is called the draft Article 7 on immunities. Immunities of state officials from foreign criminal jurisdiction. The draft article was proposing that there is enough material in state practice to say that there are exceptions to immunity. On that point there was voting, and after a voting, often which is not the case, as I said, by unanimous view, the provisions are sent to the drafting committee. The drafting committee is a very interesting place. It is a much smaller community, it's a much smaller composition. It's voluntary, any member can join. Not all members like to join, members depending on their preference and choice and interest of particular field decide whether to join or not to join. A plenary normally takes place in a big hall with a big podium and everybody can see and people are sitting behind. But the drafting committee takes place on a single table with everybody sitting around the table. In the plenary, members come with written speeches and read out the written speeches. But in the plenary, it's impromptu. That is, anybody can take the floor and express his or her views. And there is an exchange of views. Some people agree, some people disagree. And then ultimately, after an exchange of views, the idea is to arrive at a consensus. And when, if not everybody, at least a substantial majority agrees that this is the view we want to take, then there is an agreement, there is a consensus, and then a certain provision is adopted. Now there are two very important things that are discussed in the drafting committee, which are very, very crucial for the codificatory and progressive development process. First, finalizing the philosophy behind the provision, and secondly, representing that philosophy in actual text. So the first point of consensus has to be whether we all agree what is the objective of that provision. So all the members of the drafting committee have to agree on the philosophical background, or the conceptual, or the jurisprudential background, what the provision seeks to achieve. That's the first thing they have to agree on. And once they have agreed upon that, then they have to agree upon what is the exact text that is going to represent that feeling. Because we might have a certain thought, but if the text is not representing it, then the consequences would not follow. And therefore what is important is, therefore you often see that the members of the drafting committee are fighting over a comma, over a full stop, over a colon, over a hyphen, spending hours together, whether it should be and or it should be or, but it does have very serious consequences because we don't know in which context that provision will come up for interpretation. It might come up in a dispute before the International Court of Justice. It might come up in a dispute which is being bilaterally resolved between states by negotiation or in any other manner. So one has to be very careful about the consequences of this drafting process on the future. So we do take a lot of time in the drafting committee. The discussions of the drafting committee are confidential. The idea is that the members should be able to freely express their views. Absence of recording also makes it at times tense, but at times very playful. But the beauty of the commission is that the members of the commission often disagree and disagree wildly with each other. When they begin, they are actually standing on opposite poles. But by the end of it, you often see they all start converging around certain ideas. Members coming out with innovative proposals to reconcile differing views, members willing to step back, members taking a certain position and saying, well, I don't think that was the right thing for me to do, I want to step back. I can tell you from my personal experience, there was a provision which was being discussed about jurisdiction of the International Court of Justice on the topic of peremptory norms. And I was opposing it. I was saying, no, we should not have a provision on jurisdiction to the ICJ because this is a non-binding text. In a non-binding text, you can't refer it to the ICJ. And then next day morning, one of my colleagues who was taking a completely opposite position, saying it has to be there, took me out for coffee and explained what his position was. And then he showed me the drafting history of the Vienna Convention and why that provision was inserted by the Commission and why it is so important to have a compulsory jurisdiction on ICJ, especially in relation to peremptory norms, because otherwise any state can simply say, I don't want it, and get wriggled out of the treaty. And then next day morning when I came to the, or next day afternoon when I went to the drafting committee, said, I've changed my views and I'm willing to go along with the majority, and then the majority took its course and it adopted. So we are always, people have made far more greater concessions than I have, but I just gave the example because it just struck me. It also represents the collegiality. And this collegiality is a very important response to often what critical international scholars call it as a Eurocentric exercise, or say international law is European, or international law is against the third world, or international law is against developing countries. I have always felt in this philosophy that at these international fora, there is a neutralizing effect. The neutralizing effect is that we all come from different backgrounds, we all have different priorities, but when we sit together, when we discuss them, what comes out is a consensus document, a document on which we all are willing to put our mark, to put our agreement. It's pretty much a reverse prism incident. You know a prism, if you put a ray of light, you have several colors coming out. A reverse prism, according to me, is when you put several colors, one by